The Twitter saga carries on. New owner Elon Musk is facing several lawsuits from workers who were fired when Musk took over the social media company. He also issued an ultimatum to those that were left that they commit to being extremely hardcore and work long hours of high intensity or resign. Is that something a boss can legally do? Employment lawyer Alex Lucifero joins us now with more. So, Alex, do employers have the right to insist that employees work overtime hours?
Well, they certainly don't have the implied rights to do it. So, in other words, they need the employee's consent. Now, that consent can be given in a couple of different ways. Certainly, you can ask the employee if they're willing to work overtime, and if they agree, well, then that's absolutely fine. There's no issue with that whatsoever. It could also be a contractual term. So there could be, a provision or a line in your employment contract that was agreed to at the time that you started employment that requires you to work overtime, or that at least allows the employer to request that you work overtime from time to time. That would be another way contractually in which an employer can impose overtime on an employee. Otherwise, again, as I mentioned, they need the employee's okay, they need their consent.
So again, then what would happen? What options would an employee have if they don't want to work those additional hours?
So it's a question of degree. Again, certainly without their consent, they can't be forced to. So employees should feel comfortable enough and confident enough to say no to an employer if they're unable to work those hours or unwilling to work those hours. It's also the case, and this would be the case when we're talking about Twitter here. If an employer's increasing your workload, asking you to work significantly more hours, and potentially for no better pay, really, that would be what's called a constructive dismissal. That may very well be a termination of your employment. It's effectively a breach of contract. Any kind of significant change to the terms of your employment, including increasing your workload in a significant way, can be considered a breach of contract, at which point those employees would very well be owed severance based on their age, position, and years of service.
Okay, and are you able to just go into a little bit more detail? Because if they are let go because they refuse the increased workload, then that would be a case for severance.
It absolutely would. Again, it's called a constructive dismissal. It's basically a breach of contract in the context of an employment relationship. And when an employer forces an employee into a significant change, that employee could say, no, I'm not accepting that change. I'm considering it a breach of contract. Severance, again, is based on an employee's age, position, and years of service. The longer you've been with your employer, the more severance you're owed. And that also takes into consideration your age and your position. The more specialized your position is and the older you are, the more your severance entitlements increase. Severance could be as much as 24 months for longer term employees or employees of, kind of senior level, management level employees. And so even, it could be the case that severance is significant for these Twitter employees. And we're talking about employees in Canada that are being asked to do this job. And, depending on their length of service, we'll be talking about months and months and months of severance. We're not just talking about a few weeks here.
Okay, Alex Lucifero, thank you so much for your time on this tonight.
My pleasure.